The brutal war in Ukraine has shocked the world. Can Russia be held accountable? And what are the challenges for justice? Welcome to Raoul Wallenberg Talks. Today we are going to talk about international crimes and, among other things, sort out what war crimes and crimes against humanity are. With us we have Mark Klamberg, professor at Stockholm University, here to help us deepen our knowledge about this truly important subject. We do have a chat today, so please write your questions and we will get back to them later. But now, welcome Mark, the stage is yours.
I want to thank you for this opportunity to talk about war crimes and crimes against humanity in the context of the conflict that is happening now in Ukraine. I've divided this talk in three parts. First, I will give you a history of war crimes and other atrocity crimes. Next, I will talk about the importance of this topic. And lastly, what it means for Ukraine. And starting with a history of the concept of war crimes and other international crimes. This is a picture from Solferino, the Battle of Solferino, 1859. And this depicts when Henry Dunant came to the place after the battle, and he saw thousands of wounded, dying, or dead persons. And he was shocked because they weren't taking care of these persons. And this gave the impetus for him to be one of the co-founders of the Red Cross in 1863. And this is perceived as the starting point of modern international humanitarian law and also the concept of war crimes. The other person that is often mentioned in this context is Lieber. And Lieber was an German-American who was tasked by President Lincoln to write an instruction for the Union forces on how to fight and treat prisoners during the American Civil War. So this is the traditional story, these two persons, of how kind of modern laws of war were established. One could tell more stories, and in this context, I would like to tell you one more story. And it's one could start this story almost 50 years earlier, with the Treaty for the Regularization of War in 1820, which was an agreement between Bolivar, who was fighting for independence in Latin America, and a Spanish general. That's kind of normally not mentioned, but I think that's part of the story as well. So this led to attempts to regulate this on an international basis. There were several conferences, and of particular importance is the two Hague conferences, 1899 and 1907. And these were the first multilateral international agreements between states to regulate the conduct of war. And it's in the context of the Ukraine conflict, it's worth it to mention that the first Hague conference, the initiative for that was from Tsar Nicholas II of Russia. It wasn't, one would say, kind of a humanitarian endeavor. It was more that Russia at the time felt that they were left behind in the arms race, and they tried to regulate that. But it was an important starting point for regulating laws of war. All of these rules were important for the conduct of the World War I, or rather in the aftermath. In Versailles, the peace treaty, it was regulated that the persons that were perceived as the perpetrators or responsible for the war and the atrocities committed should be brought to justice, in particular, the Emperor of Germany. This did not happen. The Emperor fled to the Netherlands. The Allies couldn't get him extradited. There were some other trials in the aftermath of World War I. One was the trial of Sogmoran Tillerian, not very known today, but I would say very important. Tillerian was an Armenian who wanted to have some kind of justice in relation to the Armenian genocide. And he killed the former head of government of the Ottoman Empire, and he was brought to justice in a German court. And eventually he was acquitted by the jury. And the reason why I'm bringing up this trial was that this was something that people were talking about in the 1920s, justice for the Armenians. And one of the persons who was concerned by this was Raphael Lemkin, a Polish Jewish lawyer. And he started to work on this, and eventually this led to him writing the book Axis Rule in Occupied Europe, 1944, where he introduced the concept genocide. And in his autobiography, Lemkin writes about the trial of Tillerian and how that inspired him. Another trial in the 1920s was the Leipzig war crimes, which at the time were perceived as failures, but still created important precedents for what happened later. Other important developments in the 1920s was the Kellogg-Briand Pact. Kellogg was the state secretary of the US, and Briand was the French foreign minister. And they signed a pact with several other countries to renunciate war as an instrument of national policy. So this was the first international document which outlawed the initiation of war. This brings us to the Nuremberg trials, 1945 and 1946, where the leaders of Nazi Germany were brought to justice. And they were indicted for 4 crimes. It was crimes against peace, and that related to the 1928 treaty where war was outlawed. They were indicted for and prosecuted for crimes against humanity, which include extermination, what happened in the death camps, and war crimes. The 4th crime was conspiracy to commit the other crimes, in particular crimes against peace. And one of the defenses of the accused was that this was some kind of retroactive legislation. And the tribunal solved that quite easily when it came to war crimes, because there were treaties, Geneva Conventions, the 2 Hague treaties from 1899 and 1907, which I mentioned. There was the Kellogg-Briand Pact, which outlawed aggression. The tribunal had some difficulties with crimes against humanity, but they solved that as well in the view of the tribunal. And so this was the first time when you had an international tribunal which convicted state leaders for war crimes and created a hugely important precedent. A further consequence of World War II was the adoption of the 4 Geneva Conventions to create a better protection for prisoners of war, civilians, and other categories which needed protection during armed conflict. And as you can see here on the screen, it's four conventions. These conventions, they were primarily created as a response to World War II and created for a similar war between states. And what states observed and others was that the conflicts in the 1950s and 1960s, there were less and less conflicts between states and rather conflicts within states. And the protection created in 1949 was considered to be inadequate. And as a response, 2 additional protocols were adopted in 1977. The first one, protect victims in international armed conflicts, and the second, protect victims in non-international armed conflicts, or what we normally describe as civil wars. There were other rules and agreements adopted in the aftermath of World War II. It was the Genocide Convention in 1948. Here we can see on the left Raphael Lemkin, who coined the word in the book 1944, and he campaigned for this convention to be adopted, which happened in 1948. And genocide is sometimes portrayed as the most serious crime. It's defined as in 5 different acts, which have to be committed in a certain context. And the context is that it has to be done with the intent to destroy one of 4 protected groups. And protected groups, with that we mean groups based on race, ethnicity, religion, and it's group based on national, ethnic, racial, or religion. So that's the 4 protected groups. There was also the Declaration of Human Rights. Here we see Eleanor Roosevelt. And the idea was to pronounce these rights and later to have them codified in treaties. And we can see that we have several treaties adopted within the UN after this, most notably the UN Convention on Civil and Political Rights, but also the Convention or the Covenant on Social, Economical, and Cultural Rights. So all of this happened in the aftermath of World War II. Now, this presentation is about war crimes and other atrocity crimes and how to investigate and prosecute them. And there's different ways of doing this. I'm trying to describe this in this table. And one could conceive of 4 different alternatives. One can have either a domestic or international court, which you can see on the horizontal axis, and then on the vertical axis, one could imagine that you either have a domestic penal code or an international penal code. And it's especially kind of 2 categories which are we can observe in the real world. And it's primarily international courts which apply an international penal code. So there we have, for example, the International Criminal Court, which I will speak about. And then we have a domestic courts which apply a domestic law where war crimes and other atrocity crimes have been defined in national law. So that's the 2 kind of most common alternatives, alternative 1 and 4 in this table. So what happened after World War II, the Nuremberg trials, was that there was an attempt to establish an international court already in the 1950s. That didn't happen because of the Cold War. Instead, we had to wait until the 1990s when the Cold War ended and the Security Council could start to work as it was intended. And we also had very serious conflicts, one in former Yugoslavia, and we also had the genocide in Rwanda. And as a consequence of that, the UN Security Council established 2 tribunals. The first one was the International Criminal Tribunal for the former Yugoslavia, where leaders from different parties to the conflict were brought to justice in The Hague. Here we have a picture of Milosevic. The other tribunal was the International Criminal Tribunal for Rwanda. It had its seat in Arusha, Tanzania, neighboring country to Rwanda. And here the leaders or the main responsible for the genocide in Rwanda were brought. They also had numerous trials and processes in Rwanda, most notably Gakacha processes, a kind of village justice. So it was hundreds of thousands of victims and thousands of perpetrators that needed to be brought to justice. These 2 tribunals were advancements in international criminal justice. However, they were criticized in the sense that they were limited in time and scope. They were set up after the atrocities were committed. And parallel to these proceedings, there was work to establish a permanent court, which potentially could take on cases from all over the world. and that is the International Criminal Court. It's based on agreement from Rome in 1998. The treaty, the Rome Statute, came into force the 1st of July 2002, and that's when the court was established. Here we have the picture of the court, of its building. And the jurisdiction of the court, the cases that it can take on, is limited. So it's limited to certain crimes. So it's war crimes, crimes against humanity, genocide, and now lately also the crime of aggression. I mean, to illegally wage war. The jurisdiction is also limited by time. The court can only take on crimes which were committed after it was established, the 1st of July 2002. It does not have universal jurisdiction, so it's limited in the sense that there has to be a connection between a state that has accepted the Rome Statute, between that state and crimes committed on its territory, or the court can also take on crimes of nationals to a state party. So let's say, for example, Sweden is a state party. That means that the court can take on crimes committed on Swedish territory or outside of Swedish territory by a Swedish national. The dilemma with the present conflict between Ukraine and Russia is that none of these two states are parties to the Rome Statute. However, there is a possibility for non-state parties on an ad hoc basis to accept the jurisdiction of the court. And that is what Ukraine did in 2014. And that is why the International Criminal Court has jurisdiction over crimes committed in Ukraine, both by Ukrainian forces and Russian forces. So there's no limitation in that sense. Furthermore, the court's jurisdiction is affected by the principle of complementarity. And that means that, let's say that a country wants to conduct national investigations and prosecutions, and the ICC at the same time has an investigation into the same situation, then it's the national investigation and prosecution that goes first. And that is the principle of complementarity. And in the context of this present conflict, that means that if Ukrainian investigators and prosecutors want to pursue a case, they go first. And it's only if Ukrainian or Russian or other countries are unable or unwilling to prosecute a case, that's when it comes to The Hague. Now, I've mentioned domestic investigations and prosecutions. Here we have pictures from a case in Stockholm District Court, which was concluded in March this year. And we've had 14 trials in Sweden concerning war crimes and genocide. And this is a testimony to the fact that these type of crimes can be investigated and prosecuted in an effective way on a national level. The case, the pictures you have in front of you is concerned a woman who traveled to Syria with her children, and she was held accountable for her children or one of her children being recruited and used as a child soldier, and she was convicted for that, for not preventing that. Now, turning to the Russia-Ukraine war, a little bit of context, because when we're talking about war crimes and other atrocity crimes, they're committed in a certain context. And they have to have a connection, if we're talking about war crimes, to an armed conflict. And it's many types of atrocities we're seeing. We're seeing killings, murders, abduction, torture, and so on. For the context, it's also important, I think, to consider why is Russia conducting this war? Why did they start it? And from the Russian side, for some years, they've talking about the threat from NATO. However, I think we have to consider what they're actually saying to the rest of the world and to their own population. And here we have excerpts from an op-ed in a Russian news channel. In this op-ed, it's talking about brutal censorship of the Ukrainian culture, large-scale re-education, de-Ukrainization, and that the word Ukraine itself cannot be allowed to exist. And this is not only an op-ed, we can see this from other top-level officials. Here we have Dmitry Medvedev, who's not talking in the same extreme words, but basically it's about Ukraine ending its status as a sovereign state and for Russia to dominate. And we can see similar statements by President Putin. And this is important when we consider, for example, whether this is a genocide or not. Is there an intent here to destroy in whole or in part the Ukrainian people? I don't know if we have evidence enough, but this is a type of evidence that may be relevant if we're discussing genocide. We also have the crime of aggression to illegally wage war. And in the UN Charter, to initiate the war has been outlawed. There are only two exceptions: self-defense or when there's an authorization from the UN Security Council. None of these exceptions are applicable here. The UN General Assembly has adopted a definition of aggression in the 1970s. And in Article 3 of that resolution, they define what aggression is. It can be invasion or attack by armed forces, bombardment, and so on. So there is this list, it's non-exhaustive. But if we go through this list, we can see that Russia ticks all the boxes. So this is a clear example of aggression and a violation of the UN Charter. We also have several different kinds of war crimes. We saw when Bucha was liberated, executions, rapes. We can also see how the Russian State Duma has adopted a law which legalizes under Russian law the abduction of children. We can see bombardment of civilians and civilian objects, houses, and large-scale rape. So all of this are potentially war crimes. They need to be investigated, and they are also investigated. Primarily by Ukrainian authorities, but there's other countries who have also initiated national investigations, including Estonia, Lithuania, Germany, Poland, Slovakia, and Sweden. And the primary purpose of these national investigations is not to have trials here in Sweden or in Germany. It's to collect evidence, which can be transferred later to Ukrainian authorities or to the International Criminal Court. We also have international investigations and prosecutions at the International Criminal Court. A EU body, Eurojust, is coordinating this or helping the states to coordinate. They don't have their own investigators and prosecutors, but they can assist by setting up joint investigative teams and provide tools on how to investigate and prosecute this in efficient ways. To the right, you can also see the first trial conducted by the Ukrainian authorities against a Russian soldier who was convicted for killing a Ukrainian civilian. Now, lastly, there's different ways of extracting responsibility. I've been mostly talking about individual criminal responsibility, how to hold individual soldiers or their leaders responsible. In parallel to that, we also have state responsibility. And states can sue each other. And one of these forums, or the most obvious one, is the International Court of Justice. It's also in The Hague. So it's two separate courts, both in The Hague. And Ukraine, already when the present invasion started, they filed a complaint to the ICJ under the Genocide Convention. And the result of that, we can see on the top here that the ICJ ordered Russia to cease all actions in Ukraine. And that is what one would expect or hope from this court. But this case is a little bit odd, I have to admit. So I'll try to explain what is odd about this. This case was brought to the court under the Genocide Convention. I mean, it would be more obvious to bring this as a violation of the UN Charter. Why did they bring it under the Genocide Convention? The reason is that the ICJ does not have automatic jurisdiction. Parties to a dispute, they have to accept jurisdiction of the court. And they can do that in relation to a particular dispute, or they can do it beforehand in relation to all potential conflicts. And Ukraine and Russia hadn't done that. Russia would never accept the jurisdiction of the court if they were sued by Ukraine. Instead, Ukraine brought it under the Genocide Convention, because in the Genocide Convention, there's a clause which says, if there's a dispute in relation to this convention, it can be handled by the International Court of Justice. So that's why Ukraine brought this case under the Genocide Convention. But then we have to remember that who made the case or the argument about genocide first? Well, that was Russia. Russia claimed that they needed to invade Ukraine because Ukraine was committing a genocide against the Russian minority in Ukraine. And that's why I have this last picture. So what Ukraine argued was that Russia is abusing the Genocide Convention. There's no genocide committed on behalf of Ukraine against the Russian minority. This is abuse of the convention. And the ICJ gave Russia the opportunity to bring evidence to somehow substantiate their claim. Russia didn't do that. And the court concluded that Russia had abused the Genocide Convention. That was the first thing. And second, that Russia had to cease with their military operations. And that was in an order on provisional measures from the 16th of March 2020. So to conclude, we have individual criminal responsibility that can be pursued in national courts and the International Criminal Court. And then we have state responsibility, and one of the venues for that is the International Court of Justice. And that was the end of my presentation. Thank you.
Thank you so much, Mark. And for those of you watching, please write your questions in the chat. Now with us we also have Sally Longworth, doctoral candidate at Stockholm University. Welcome, Sally.
Thank you very much, and thank you for having me.
Now your research focuses on the right to freedom of expression in armed conflict. Now based on your research, if we look at Ukraine, could you tell us about what some of the key concerns here are?
Well, my research reveals how freedom of expression and access to information are crucial for ensuring respect for international humanitarian law, the area of law that regulates how the parties to the conflict conduct the hostilities and protection of people who do not or no longer participate in the conflict. And in doing so, ultimately prevents atrocities from happening. So one area that has been brought up many times since the outbreak of hostilities in Ukraine since 2014 are discussions about misinformation and disinformation by the parties to the conflict. And in my research, I make a distinction between the two, misinformation being the spreading of false information, and disinformation, which can include false information, but can also include information that is accurate, but framed in a way so that people who receive it draw false or inaccurate conclusions. And the example that Mark referred to just now of Russians' allegations that there was a genocide happening in eastern Ukraine is one example of this. It deflects responsibility away from the Russian activities and creates doubt as to what exactly is taking place. It's then combined with rhetoric about an anti-Russian campaign, and that results in other states and other international bodies being unable to react to the actual event sufficiently as they try to respond to the allegations that have been made. And when the parties to the conflict spread disinformation, it creates confusion around the events that have taken place and responsibility. And in doing so, it calls into question the core obligations of all parties to the conflict to respect international humanitarian law. It also creates a space where other violations of international humanitarian law and human rights law can occur. And that undermines the obligation to ensure respect for IHL. That is, that the parties to the conflict need to ensure that all persons, soldiers and civilians alike, respect IHL within the conflict. It also interferes with people's right to freedom of expression. It spreads mistrust in the information sources. It interferes with people's right to freely form their own opinions by creating a very biased landscape in the information they receive. And it makes it very difficult to find out what is actually happening if there have been international crimes or other breaches of international humanitarian law. So it affects both the individual and the society at large.
I guess, Sally, that today, with this complex media landscape that we do have, this is something, the situation today must be different from the situation 50 years ago.
Yes and no. The technology is different. The ability to spread a message is different. It can go much further, much faster nowadays. But these types of activities have been a feature of armed conflict for many, many years, for centuries. And as with the law of armed conflict, we can trace the history of kind of propaganda activities, if you will, right back from to the beginning of time, where we've been doing it since we've started these kind of actions. But the technology that we have today has made a difference in how far the message can go and how quickly that can be. So that then impacts on that then changes the impact of the message, which can be much better.
Is this something that also could affect the courts?
Yes, exactly. So one of the things that we're seeing with this is, as the parties to the conflict use the information sphere so as to guide the hostilities and also to create doubt as to what happens, that information is exactly what courts and processes afterwards use to determine what the facts are in this fog of war, as it's kind of traditionally referred to. But this is then also where IHL and human rights law have such an important role to play in ensuring that there is information there to test before a criminal trial. And that's part of the reason why a specific obligation was included in additional protocol 1 to the Geneva Conventions that applies in international armed conflicts on the protection of journalists to ensure that they are still able to carry out their function and have protection in armed conflict the same as civilians.
And I guess also that the amount of data when it comes to the spreading of misinformation and disinformation is huge. It must be a great task just to start working through it and to get a picture of what's actually happening.
Yeah, exactly. And this is in part one of the tactics that is being used to throw out as much information as possible to make it so very difficult. It also brings up new and very interesting complexities, not only in how we use the information and how that can be tested before evidence in court, but also questions on how we conduct those investigations, privacy issues, data protection, and similar questions of law that we are working through presently.
Do we see any new strategies when it comes to the spreading of misinformation and disinformation, or is it too early to say something about that?
There are many, many different strategies that have been used. We've seen some differences. So in the very beginning of the conflict, there was a lot of, so back in 2004, with the outbreak of hostilities and the occupation in the eastern Ukraine and the occupation of Crimea, you might remember there was lots of discussion about what were called troll factories. Yeah. That were private companies, and there was lots of discussion about their links to the Russian state and how much involvement, control, direction the state had in guiding their activities. and the spread of misinformation by those actors, which still exists and is still a thing. But we're seeing lots of other methodologies and different bodies being used. We're also seeing a significant difference in the two parties to the conflict, obviously, in how they are providing information to their own population. So within Russia, we've seen significant restrictions on freedom of expression and censorship of journalists and other media workers and all persons within Russian jurisdiction. For example, legislation was passed that if you spread fake news, then you could face a fine and up to 15 years imprisonment. Fake news being defined in that context at the moment as even referring to what's happening in Ukraine as a war. It's referred to by the Russian government at the moment as a special operation. So there's a significant difference of what's going on and the approach to information, but also then the approach to these obligations and how you demonstrate respect for both international humanitarian law and international human rights law.
Could you tell us some more about how this impact on the criminal investigations that Mark has spoken about?
Well, for example, in relation to allegations of sexual violence that have taken place in this conflict, investigating these crimes is difficult in any circumstance. Armed conflicts add new difficulties when capacity and resources available to investigate are not the same, but also where victims may have fled the conflict area. So there have been numerous reports, for example, of Ukrainian women who have fled to Poland being unable to access medical and other support that they need due to the extreme restrictions on reproductive rights there. So as a result, the victims of these crimes are unwilling to speak out because of the complications that this can bring in accessing medical services. And then that's how we also see how upholding these obligations, it's not only essential for the parties to the conflict, but everywhere.
Well, thank you so much. And I'd like to welcome Mark back to the scene. And thank you all who's watching, who write questions in the chat. We'll get back to them just in a minute. Now, Ukraine has, as you said, Mark, already completed its first trial and others are ongoing. But is it really suitable to prosecute war crimes and crimes against humanity during a conflict that is ongoing?
I think that's a relevant question. I think that there are important considerations here. I'm thinking primarily about the rights of the defendant to a fair trial. And I think it's possible to have a fair trial during an armed conflict. Having said that, I think there are some relevant questions that have been raised, both, in relation to the Ukrainian trials so far, but even more so to the trials which have been conducted by Russia against three persons who served in the Ukrainian army but are non-Ukrainian nationals.
But I guess do you think it's a different pressure on the courts being in a war and having these kind of trials from the public that you actually get convicted? Are the courts ready to stand that test, do you think?
Well, I think one important feature is that if the trials are public, and that gives an opportunity for outsiders to have some kind of picture or understanding about the conduct of the trials, if they're fair or not. Having said that, I think there will be cases that are even more controversial than the ones we've seen so far. And my understanding is that if there are persons on a higher level who are apprehended and are going to be subjected to a trial, that will be at ICC. So if we see generals or even kind of politicians, I don't know if that will ever happen, but as I understand, the idea is that they will be brought to the ICC, and I think that could relieve some of the concern when it comes to bias of the courts.
Yuken Nyberg has written a question from you in the chat. He says, roughly how many countries in the world have national legislation and investigative and prosecuting authorities in relation to international criminal law? And is this number increasing?
I don't have an exact number. However, all states are parties to the Geneva Conventions. And that means that they have an obligation to have this kind of legislation and to enforce it, either by bringing persons to their own courts or to extradite them. What we can see is that with the establishment of the ICC, which has more than 120 state parties, most of these states have adapted their legislation in order for them to be up to date with the Rome Statute. So I would say there's most states have legislation which kind of allows for these type of investigations and prosecutions. But that brings us to the second aspect of the question, which is maybe even more determinative. It's if you have resources to do it, if you have investigators and prosecutors who are actually working with this. And here we can see that some states in Europe have been more able and willing to do so. I'm thinking about countries such as the Netherlands, Germany, and Sweden, while other countries in Europe haven't resourced their police and prosecution in the same way. So I think that is at the moment the more critical question, to have well-resourced investigators and prosecutors.
The obligation to prevent international crimes that we find in the Geneva Convention and elsewhere, it relates not only to the other side. So there's a huge emphasis at the moment in this context about bringing prosecutions against the adversary's soldiers. But the Ukrainians have an obligation to investigate their own soldiers, as do the Russians. The Russians have that obligation as well. So everyone has to have this capacity, because as part of the obligation to ensure respect for international humanitarian law, you have to make sure that your own soldiers and everyone else within your jurisdiction is also complying with IHL. So it's a very important, I think the emphasis should also is important to think about there, that there is capacity everywhere, because you have to have some form of capacity. As Mark said, some have invested considerably more resources than others.
And if we look globally, democracy in the world is under enormous pressure. We can see states moving from democracy, moving away from democracy. How worried are you about this system as a whole when we see that states are going to move away from democracy in the pace that we are going to in the world now?
Well, one problem is that the countries where we can see conflicts or authoritarian rule, that also tends to be the countries which are not parties, for example, to the International Criminal Court, and which to lesser or no extent at all are investigating and prosecuting crimes. So as I see it, this goes to a large extent hand in hand, whether you have democracy on the one hand and structures, institutions within your country to prevent these type of atrocities, and if they happen to prosecute them. So this goes hand in hand, and obviously the trend kind of towards a regression when it comes to respect, rule of law, and democracy and human rights is also a problem in this context when we're talking about international criminal justice.
To take the composition, though, there is nothing within the Geneva Conventions or within the ICC statute that requires a democracy. It's within the state's own sovereignty to determine their own political system, and that can be something else than democracy. Now, there is a huge link, obviously, then between human rights law and democratic structures, and as Mark said, of those being hand in hand with actually being able to uphold these obligations in a proper manner. But I think it's also something that we're going to see, hopefully, as an outcome of this conflict, of reaffirming commitment to these standards that have been agreed and have been in place for centuries now. The wounded, sick, and injured being evacuated, for example, protection of prisoners of war. These are very, very, very old rules. They do not require modern structures of democracy as we have now, but they are essential for ensuring protection during armed conflict and to reduce the impact of the hostilities on those that are not participating.
And if I may add some more on that, I mean, I think in the context of this conflict, it's important to stress that Russia has, during periods in history, been pushing for these type of rules. I mean, if we think about the two Hague treaties, I mean, it was Russia who took the initiative for the first Hague conference. And when the Geneva Conventions were negotiated, I mean, Russia was taking part and contributing. So even if we talk about authoritarian or non-democratic states, they have been involved. They have their parties to the treaties and should be committed to respect these rules.
We have a question from Nikita as well here, and she asks, are journalists allowed to carry weapons with them to defend themselves during a war?
That would be subject to national legislation. So the protection of journalists within international humanitarian law is a little bit different from how we see, for example, medical personnel. So military medical personnel are allowed to carry a weapon with them for personal protection. That's regulated within international law. That it's, you know, it says if they have such a weapon, a small caliber weapon with them, that they do not lose their protection just because of that. There's nothing within international humanitarian law that regulates whether or not journalists can also. Journalists are entitled to the same protection as civilians. So if civilians within the domestic system are able to carry weapons like that as a means of self-defense, then so would a journalist.
Yeah.
Yeah.
Well, thank you. We're going to wrap up here, but what impact do you think this war will have on international law in particular and human rights, international humanitarian law, and international criminal justice in particular?
Well, we can see a lot of support from several countries for these investigations and prosecutions, and that's something positive. What I would hope is that we will see the same level of commitment and support when atrocities are committed elsewhere. So that's what I hope. Now, this conflict can be a starting point for a more robust work when it comes to bringing persons to account. However, that's on the positive side. On the negative side, it's a huge problem that the world appears to be more and more divided, and it may also create negative consequences for international law and the respect for these rules. So it's difficult to predict what consequences this will have for international law. Obviously, it's a great failure that the conflict escalated into full-scale war, as we can see it now. But hopefully, it will bring something good as well.
I think there's negatives and positives in both, but historically, events similar to these have reshaped the whole international legal system, resulting in a strengthening of rights and protections for individuals. But that can be a very long, windy, and dangerous road that we embark on. So we'll see where we end up.
In the beginning, I asked the question, can Russia be held accountable? But if Russia can be held accountable, what time scope are we talking about?
I think if we're talking about the individual soldiers, and we can see that in a way justice is already operating now. However, if we're talking about the leaders of Russia, primarily Putin, I don't think we'll see him brought to justice before we have a regime change in Russia. So, there your guess may be as good as mine, and then we could talk about decades or never. But I think in order to bring people such as Russia and kind of at the top level, there has to be a regime change in Russia for us to see that.
I think it also depends on your definition of justice. If we're talking about reconciliation and rehabilitation between communities, that is likely to take a considerably longer period of time. But we also need to bear in mind that there are still individual claims for reparations from World War II that are still being satisfied today. So justice is not something that can be delivered in a rushed manner, I would say.
Mark and Sally, thank you so much for participating today.
Thank you.
Thank you.
This was our second talk in a series of seminars about human rights, and we do these talks because we need to talk more about human rights, and we need to bring more people into these discussions. Raoul Wallenberg Talks is arranged by Raoul Wallenberg Institute and Altitude Meetings with the kind support from Sparbanksstiftelsen Finn and Sten K. Jonssons Stiftelse. In the near future, you will also be able to listen to these talks live at Stadshallen in Lund. Please follow Stadshallen, Altitude Meetings and Raoul Wallenberg Institute online for info about upcoming events. Thank you so much for watching.